And welcome to the GC channel, to our virtual audience around the world. This is a channel especially for general counsels and in-house legal teams by general counsels. We're going to be covering some of the most trendy topics that are keeping you up at night, and we really hope that you'll find the next few minutes insightful and useful information. Talk to you very soon. One of the things that we pride ourselves in the GC channel is to try to minimize the amount of drama that goes on in the relationship of the in-house team and the external counsel. And so would you say that this whole GDPR, post-GDPR and data privacy in light of developments, both you mentioned the Shrimp's case, but you also know some developments are going on in Asia, for example. Do you think that this has been highly dramatized by external law firms, because that's how these big firms get their clients to come in and ask for advice? I mean, what would you say to those in-house legal teams that are looking for this level of advice? Is it really that significant in terms of the exposure? Can it be fairly managed, without a lot of the hyperbole that goes on by external counsel? How would you guide them to secure their exposure, minimize any risk, but at the same time not break the bank and go into price sticker shock as they go to an so-called expert boutique law firm?
Well, that's an excellent question, because there is, a tendency for lawyers and consultants to be a little alarmist about this. And there's always the temptation to play, Chicken Little and say the sky is falling. To give an example, talk about one of the trends that's been a little scary, which is the trend toward data localization. So you definitely have jurisdictions in the world like Russia and China and Kazakhstan, and Vietnam, that have adopted laws and regulations in very recent history that push enterprises to keep personal data, and often other categories of data, such as data that is involving critical infrastructure, or that potentially involves national security interests, or in certain key kinds of economic data in the country. And it's often not clear whether that means you just have to keep a copy of the data in country, accessible to the individuals that are affected, or to the regulatory bodies that are affected, or the relevant ministries. And you can also mirror that data at the home office outside the country, or whether you really only can keep the data in the country. But that's often vague. But that data localization trend is often driven by nationalistic kinds of politics. It's often touted as a way to protect the citizens of the country, or to protect the country from being spied upon or dominated by Western global companies, for example. So it's often highly advertised and promoted in terms of sort of nationalistic politics. But when you get down to practice, it's often not fully implemented in as draconian as a way as it's publicized. So that, to take a recent example, if you look at the cybersecurity law in Vietnam, when you read it on its face, it sounds like just about every company would have to keep its personal data and records of online transactions in Vietnam. But when you look more closely at how it's actually implemented by the Public Safety Administration, you find out they really only require that if the company has some history of violating rules in country and they don't trust you. And otherwise, you really can let the head office in Paris or New York keep the data and it's only in certain circumstances that you're required to keep the data in Vietnam.
So we'd like to thank you for your attention in the last few minutes. We hope that you found this GC channel broadcast insightful and useful. And we look forward to having your comments. Make sure that you subscribe and you leave your questions with us. And we promise that we'll get back to you very quick.